All right, the first bill up, House Bill 146. Secretary will read.
House Bill 146 by Representative Weldon of the 3rd and others. A bill to be entitled an act to amend Title 17 of the OCGA relating to criminal procedure so as to change provisions relating to the issuance of arrest and search warrants by video conference and for other purposes. The Committee of the Senate on Judiciary and Non-Civil recommends that this bill do pass by substitute. The Judiciary and Non-Civil Committee offers the following substitute to House Bill 146. A bill to be entitled an act to amend Title 17 of the OCGA relating to criminal procedure so as to revise provisions relating to arrest and search warrants and for other purposes. Through with the order, Mr. President.
Chair recognizes the very distinguished Banking Committee Chairman, the Senator from the 13th. Tift County's finest.
Thank you, Mr. President, distinguished members of the Senate. It gives me a great privilege to present to you House Bill 146. Actually, this law is in effect at this time. The only change that will be made is the fact that a judge may issue an arrest warrant from anywhere in the state as long as he follows the existing law. Currently, a state or magistrate court judge has to be located in his home county, and a superior court judge has to be located in the circuit. So all this does is to provide that the judge can be anywhere in the state of Georgia and issue such a warrant. That's in regard to Section 1. Section 2 is the same principle, except it applies to a different code section. And then we go to Section 3, which concerns the issuance of good behavioral bonds. In the old days, a senator from the 24th will remember that if you had a disagreement between parties, often they would go to the magistrate judge and get what they called a peace warrant. And they was arrested and had to put up a bond to ensure that they would comply with the law. Well, in many rural areas, it's very difficult for some of the people to get access to the Superior Court for temporary protective orders. This simply provides that they can go to the magistrate judge, and if they show good cause that he will issue a behavioral bond, the hearing would have to be heard within 7 days. If the party is arrested on that warrant, then he is entitled to a hearing within 24 hours. And of course, if he's gone to jail, as I said, you got to have a hearing within 24 hours. But that's basically it. If you have any questions, I'll hear them at this time. If not, I'll vacate the well.
One question, Senator. Chair recognizes Senator from the 42nd for a question.
Thank you, Mr. President. Will the Senator yield?
Yes, sir.
This doesn't change the judge's jurisdiction, right? In other words, if you're a judge in Tift County, you can't issue a warrant that would apply in Fulton County or vice versa. It just means if I'm visiting you down in South Georgia, I can still issue one in a court where I have jurisdiction. Is that right?
That's exactly right.
Okay.
Yes, sir.
No further questions, Senator.
Thank you.
Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection to agree in the Report of Committee which fail pass the bill? Chairs none. Report of Committee is agreed to. Shall the main question be now put? Are there any objections? The chair is none and the main question is ordered. Shall this bill now pass? Questions on the passage of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will lock the machine. On the pass of the bill, the yeas are 45 and the nays are 0, and this bill MC Rex constitutional majority. It's therefore passed. Secretary will read House Bill 155.
House Bill 155 by Representatives Knight of the 130th and others. A bill to be entitled an act to amend Title 27 of the OCGA relating to game and fish so as to revise provisions concerning the licensing and operation of shooting preserves and for other purposes. The Committee of the Senate on Natural Resources and the Environment recommends that this bill do pass by substitute. The Senate Natural Resources and the Environment Committee offers the following substitute to House Bill 155, a bill to be entitled an act to amend Title 27 of the OCGA relating to game and fish so as to revise provisions concerning the licensing and operation of shooting preserves and for other purposes. Amendment 1, Senator Heath of the 31st and others offer the following amendment. Amend the Senate Natural Resources and the Environment Committee substitute to House Bill 155 by inserting after as on line 2 to authorize the use of suppressors on hunting firearms under certain circumstances, to provide for suspension of hunting privileges for persons who are convicted of hunting without landowner permission and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 31st to present the bill. No, I'm sorry. Okay, the senator from the 20th is going to present it.
Thank you, Mr. President. Ladies and gentlemen, this bill here deals with hunting preserves and how they sell their licenses, and it impacts federal revenue that we get in, that DNR could get in to help with their programs. And basically they met with the hunting preserves. They did 4 public meetings, and instead of having a blanket, you take a group down to a quail hunting plantation and they just have one blanket hunting license for the group. Well, instead of doing that, everybody has an individual license, and that way the state draws more federal revenue down to help with the wildlife programs that we have. So this is just really diversifying out and saying we're not going to do a single blanket license. We're going to make everybody buy a license, which is like $12. And so actually I don't even think the amount total would be any more that people would be paying. There were 4 public hearings that were held on this with the shooting preserve owners and to get their input in the legislation. The legislation allows shooting preserve owners a simple paper mechanism to sell shooting preserve licenses. They can do it online, but the Senate added also they can do paper copies of the hunting licenses in case of internet failure. You're way out in rural Georgia or whatever, and the internet's down, and so they can still sell the license. They just got to fill out a paper license. So that's what the Senate added in committee, and so that's why it is a substitute. The estimated amount, also with fishing involved too. You got some of these hunting preserves have ponds and people go fishing and stuff. So if they also have a fishing license, it looks like the total increase in federal funds may be from both hunting and fishing potentially as much as $1.7 million back into the wildlife fund to help DNR with the wildlife programs that they have. So this is only just making it a better system, and it also helps the the hunting preserve people. And with that, I'll take any questions or I'll yield the well.
Has the amendment been read? No further questions, Senator.
Thank you very much. Please vote yes.
Chair recognizes Senator 31st to present his amendment.
Thank you, Mr. President. Amendment number 1 brings in the language from Senate Bill 93 that we didn't get to this year, but it was also in Senate Bill 301 from last cycle. That bill passed 48-5. All this does is say that if you have a lawfully possessed sound suppressor, that you can hunt where you could otherwise hunt. Now, let me just point out that in order to have a lawfully possessed suppressor, you've got to pay a $200 fee to the federal government and get a special firearms license issued from the federal government in order to even be in possession of a suppressor. So these are not renegade folks. These are not poachers. But there was a concern about poaching, and so that's addressed in lines 59 through 63. If you use a sound suppressor and you're convicted of poaching, you lose your hunting license and your privileges to hunt for a period of 3 years. And most states, many states, we have a compact with other states. So if you lose your hunting privileges in Georgia, you lose them in other states as well for a period of 3 years. Let me say this too. Some folks want to call sound suppressors silencers. They are not silencers. They reduce the sound pressure levels of a firearm by maybe 25%. A suppressed rifle will still have a sound level about equal to a NASCAR race, the sound levels that are at a NASCAR race. So it's not like in the movies. They're not whisper quiet. As I said, this was language from SB 301 from 2 years ago, passed this body 48-5. I'd be glad to entertain any questions if there are any. If not, I'd ask for your favorable consideration.
Questions on the adoption of the floor amendment authored by the senator from the 31st. Is there objection? Without objection, the floor amendment has been adopted. Question now is on the adoption of the committee substitute as amended. Is there objection? Without objection, the committee substitute as amended is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection? Agree in the Porter Committee which fail pass the bill? Chair is none. Porter Committee is agreed to. Shall the main question be now put? Are there any objections? The chair is none and the main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor vote aye. Those opposed no. Secretary, unlock the machine. On the pass of the bill, the yeas are 42 and the nays are 4. And this bill, having C. Rex Constitution majority, is therefore passed. Secretary will read House Bill 178.
House Bill 178 by Representative Weldon of the 3rd and others. A bill to be entitled an act to amend Chapter 34 of Title 43 of the OCGA relating to physicians, acupuncture, physician assistants, cancer and glaucoma treatment, respiratory care, clinical perfusionists, and orthotics and prosthetics practice, so as to provide for additional powers of the Georgia Composite Medical Board relating to pain management and for other purposes. The Committee of the Senate on Health and Human Services recommends that this bill do pass. Amendment 1. Senator Jackson of the 2nd offers the following amendment to House Bill 178. by Section G, page 6, line 168, after pursuant to a physician protocol, insert or a certified registered nurse, anesthetist, and for other purposes. Amendment 2, Senator Staten of the 18th and others offer the following amendment. Amend House Bill 178 by striking line 131 and inserting in lieu thereof the following. All pain management clinics shall be majority owned by physicians licensed in the state and for other purposes. Through the order, Mr. President.
Chair recognizes the senator from the 45th to present the bill.
Thank you, Mr. President. Members of the Senate, I rise in support of House Bill 178. This is a bill brought over from the House that provides the Georgia Composite Medical Board authority to license and regulate pain management clinics. Licenses would be renewed biannually and are not transferable. It defines pain management clinic as a medical practice advertising treatment of pain or utilizing the word pain in the name of the practice. It also included our practices with greater than 50% of their annual patient population being treated with Schedule II or Schedule III substances for chronic pain from non-terminal conditions. The most important thing about this bill is that this is the same bill that came before the Senate last year. Unfortunately, it did not pass, and there has been a proliferation in the state of Georgia about pain management clinics. Other states have taken action against these pain clinics, and as a matter of fact, before the state of Florida deauthorized pain clinics, the state of Georgia only had 10 pain clinics. After Florida passed their law, the number of pain clinics in the state of Georgia jumped up to 140. Mr. President, I'll be glad to go through the bill if there are any questions. I do have that prepared. I'm not sure if people have questions about it, but I'll be glad to answer any questions.
Chair recognizes Senator from the 2nd on a question.
Madam Chair, do you yield?
Yes.
Does this bill in any way prohibit advanced practice nurses or nurse anesthetists from practicing their craft?
If they have a protocol agreement with an existing physician, no, it does not.
Do you further yield?
Yes, I do.
Being a nurse, you yourself, do you think that it prohibits nurses from, or discourage nurses from practicing their craft at all?
No, I believe they can go to work for the pain management clinic and be under the supervision of a physician and have a protocol agreement.
Okay, thank you.
Chair recognizes the senator from the 42nd for a question. 52nd, I'm sorry.
Will the chairman yield?
Yes, I will.
I think I heard you say that Florida had adopted a physician-only policy in their law on ownership of these clinics.
Yes, they did.
And if you'd further yield, are you aware that the Florida press has had stories reporting that pill mill operators were fleeing for Georgia?
Yes, and unfortunately they have come to Georgia, and I can give you a specific instance in my own home county, Gwinnett County, where a pain clinic was located right next to the high school that I graduated from in Gwinnett County. It was Berkmore High School. And unfortunately, they know that if they go right next to a high school, they have more traffic and more potential for growth. And that particular clinic, it was testified in the House subcommittee, the police chief from Lilburn came and said that he knew what was going on in that clinic. He knew that it was located next to Berkmore High School, but there was nothing he could do about it because we did not have a statewide law. So he had to contact the the DEA and the feds to come in and close the clinic. Well, unfortunately, that takes a lot of time. And in the meantime, that clinic stayed open. They're still peddling their pills and still making a business. And unfortunately, that police chief's hands were tied. And also, unfortunately, the children that are the end product of getting these pills have the danger of being harmed. And that's the reason we want to create a statewide law that governs pain clinics.
All right, thank you, Madam Chairman. Will you yield further?
Yes.
With Tennessee having also made laws, are you aware that there have been billboards over the state line in Tennessee that are advertising for a pain clinic in Georgia?
No, sir, I'm not aware of that, but I know that you live up next to the Tennessee border, and I am almost certain that if you saw these billboards and you know about it, that you know for which you speak.
Thank you. And would you further yield?
Yes.
Has Rick Allen, Georgia's Drug and Narcotics Agency Director, offered support for a pill mill law?
Yes, exactly. The state of Georgia needs to be able to control these personally and not have to rely on the feds to come into the state and that delay of time and the proliferation of the clinics. Yes, sir.
And if you'd yield for one more question.
Yes, sir.
On a personal note, is the chairman aware that the first takedown of a suspected pill mill was in my home district in the city of Cartersville?
In the city of Cartersville? No, I did not know that, but I know that particularly northwest Georgia with methamphetamines and the high uses of drugs, that because I work with mental health and substance abuse, I know that that corridor is one of the hottest corridors in the nation.
Thank you, Madam Chairman.
Thank you.
No further questions, Senator.
Thank you.
Chair recognizes the senator from the 2nd to speak to his amendment. Amendment number 1.
Thank you, Mr. President. Members, I rise for you to address this, to address House Bill 178. Pain clinics are dangerous in Georgia, and that we all agree to. They are a danger to our state. They are a danger to children. They are a danger to our families. But also, pain clinics allow predators to invade our state, to get these dangerous drugs to use for their selfish reasons, for illegal reasons. And they must be controlled and they must be managed. But with all that being said, that if one is a licensed healthcare professional in our state, they should be allowed to practice their craft. As with the advanced practice registered nurses. Advanced practice registered nurses have an issue with this bill. They think that there are certain things in this bill, as we read line 167 and 178, that they may limit their ability to practice their craft. And my amendment speaks to speak to this issue. Now, talking to the Attorney General's office and talking to the author of this bill, they promised that they will work to make sure that nurses and anesthetists will continue to practice their craft, that they will not be limited by pain clinics, they will not be limited by the state, they will not be limited by the AG's office because of this legislation. But we need to let healthcare providers practice their chosen craft. Nurse anesthetists, advanced nurse practitioners are vital to our healthcare in this great state. So we're going to withdraw this amendment, but we're going to work and make sure that we can practice our craft, make sure that nurse anesthetists are good healthcare providers, and that we can provide quality care for our great state. If there are no questions, Mr. President, I yield the well.
No questions. Chair recognizes Senator from the 18th to speak to amendment number 2.
Thank you, Mr. President. Ladies and gentlemen of the Senate, good afternoon. I want to begin by thanking the senator from the 45th and all those across the hall who have worked on what I consider to be an issue of enormous importance for the state of Georgia. We do have a problem, and we all agree, I believe, that we must find a way to address it. And if that requires the strengthening of Georgia's laws, then that's what we need to do. But I'm in front of you this afternoon offering amendment number 2 because I do have some serious concerns about potential unintended consequences if at least the amendment I'm suggesting is not adopted and brought into the bill. In my district, there is a group of physicians who are very reputable. They do the Lord's work in helping people who legitimately need assistance with chronic pain. They're not pill mills. They don't belong to some kind of mafia group from out of state running an illegitimate business. They are upstanding citizens in our community who are certified and who practice medicine with the highest degree of integrity. These physicians have 5 areas of practice within the state of Georgia. But one of the partners that they brought in, someone who owns 7% of their business, is a person with an MBA. His role is to help with human resources, with payables, with the business end of their practice. Now, I understand under the current bill, those physicians and their current arrangement would be grandfathered in. But it would literally mean that going forward, if they decided to do this again, a new corporation, a new business, they would not be able to do that and have that partner who has a 7% interest in their practice. I think it's a serious matter. It's a serious matter when we start saying who can and cannot own a business. Now, there are some requirements in the state law. Ambulatory surgical centers, physicians have to own a majority of those. But there are other medical practices who are now owned by large corporations, which are publicly traded, and certainly not entirely owned by physicians. There are hospitals in this state that are owned by corporations that are not entirely owned by physicians. So I think just from that vantage point, I have a little bit of heartburn, and from that point of view, I offer this amendment for your consideration this afternoon. The amendment simply says this: all pain management clinics shall be majority owned by physicians licensed in the state. Doesn't say 100%, but it says majority. I agree that we need physician involvement and physician integrity, and we need to be able to make sure that's the case in the dark side of this medical issue. But I think to say 100% is going too far, and so this amendment, if adopted, would simply change that to a majority. And then I've added one other provision because I again agree that we need as much as we can to help protect and prosecute when there are examples of illegal activity. And that's the second part of the amendment, adding between lines 162 and 163 the following: if any physician who owns or jointly owns a pain management clinic licensed under this article leaves such practice or has his or her license to practice medicine suspended by the board shall be authorized to revoke, suspend, or restrict the license of the pain management clinic. This would give the Board of the Composite Medical Board, who licenses physicians in our state, the authority when there is a bad actor and a bad character engaged in this terrible pill mill process. It would give them the ability to suspend the license for that clinic. So I hope you will join me in what I hope is a friendly and supportive and helpful amendment, but it is one that recognizes that there could be unintended consequences if we pass a bill that says no one but an MD can own or have an ownership interest in one of these practices. Thank you, Mr. President, for the time, and I'll be glad to answer questions if I can. Otherwise, I'll yield the well.
Chair recognizes Senator from the 46th for a question.
Thank you, Mr. President. Senator Yield.
Indeed, Senator.
Senator, I applaud you for bringing this. That will help free markets operate and keep business open to anybody interested in owning and providing medical services to our public. I just want to make sure and clear, I think I'm right. This composite medical board will still have regulatory authority over non-physician owners, correct?
Yeah, they will have total regulatory authority over the clinic, but this just indicates and makes it very clear that if one of those doctors is found to be a bad player and is judged to be so, then they have some authority with regard to the whole of the entity.
Thanks, Senator.
No further questions, Senator.
Thank you, Mr. President. I yield the well.
Chair recognizes Senator from the 45th. Close the debate.
Thank you, Mr. President. Members of the Senate, you can get up here and you can talk real slow and you can talk real weak and you can sugarcoat things. But let me tell you, in my book, everyone in this room knows me. And they know when they're trying to be sold something. And they know me and they know that I'm going to stand up against it. And you can talk slow and you can sugarcoat things, and you can talk about Macon, Georgia, and these fine physicians down there. And I don't doubt that that one particular practice is nice, but there's a lot of bad apples. This is the second year in a row that this bill has tried to be defeated. Now, if you want to vote for organized crime, if you want to hang a shingle on the state of Georgia and say we're open for any kind of business, I'm a Republican. I believe in free market. I believe in free enterprise. But I also know about regulation of controlled substances. This is not an everyday kind of business. This is life and death. This is when you prescribe too many pills and you keel over and you die. This is when you peddle pills to young children and you are killing the kids in the state of Georgia. Now, if you want to sugarcoat that, you can get up here and talk nice about it all day long. But I don't buy it, and the everyday citizens of Georgia do not buy it. Why do you think an unscrupulous business in Lilburn, Georgia, in my home county, in my high school that I graduated from, opens up a door, puts up a shingle that says on the front of a shopping center, pain clinic, come in and get what you want and we will deliver. Now, if you want to continue to do this for the third year, I will continue to fight for it, to regulate these unscrupulous businesses, to regulate organized crime. They have fled like roaches from the state of Georgia, from Florida. When they found out that we were going to regulate this again, the clinics started shutting down and went to another state. Tomorrow, when they find out that you defeat this bill again, they're going to come back into the state of Georgia. It's not just organized crime. It's nations around the world who pick off these states. They come in with private investors. They know that they're not regulated as heavily, and they open up shops. Now, if you want to go back to the number 140 to 200 pain clinics across the state of Georgia peddling drugs, then I suppose you vote for amendment number 2. And he can appeal all he wants to the Republican base and say that this is free enterprise. I'm appealing to every Democrat and every Republican in here to protect the children of the state of Georgia that they're peddling these drugs to. And if you want to sit there, I don't care if you're running for Congress or whatever you're running for, and you want to continue to do this on the third year, and you want to take this into your congressional campaign seat and find out what the mothers of the children of Georgia think about this, then I suppose you go ahead and vote for amendment number 2. Me, my children, my grandchildren, I'm going to fight for them. I'm going to fight for these children because I do not believe in that corruption. I do not believe in voting for organized crime. If you vote for amendment number 2, you are voting for organized crime. We have been over this bill and been over this bill. The senator from the 2nd offered the amendment about advanced practice registered nurses. That was defeated in committee, and I ask you to defeat the bill again. The advanced practice registered nurses have protocol agreements. If they want to go to work in these clinics, they can go to work in these clinics. They cannot put a shingle on the door and open up a paying clinic. That's exactly what they want to do. There are millions and millions, if not billions of dollars that can be made off of these paying clinics and people who unfortunately are addicted to drugs. If you want to keep that door open, then you just crack that door with these amendments and you go ahead and do that. If you want to shut that door down and give law enforcement, prosecutors, the Attorney General Sam Olens, who is sponsoring this bill, if you want to give him the weapons to be able to fight these paying clinics, then I suggest you defeat these amendments. And let me just throw in here, I have been to a pain clinic. I was working in my garden one day. I hurt my back. I went to Gwinnett Medical Center after about 2 weeks when I couldn't stand up straight. I got an injection in my back at a pain clinic at Gwinnett Medical Center at the hospital. After one injection, it worked. This is not who we're going after. It is not the people, the physicians who do these injections. It is the tiny pills, the oxycodone, the Xanax, the other peddling pills that they are giving to the children. They may give it to an adult who's over 18 years old, but what does that adult do? They turn around and they sell the drugs. They're peddlers. They sell the drugs, they transfer them to the children. I ask you to vote against amendment number 2. Do not buy the sugar coating. Do not buy the Republican mantra of free enterprise, free market. This is controlled substances. This is life and death. I ask you and implore to you to please, please protect the children of the state of Georgia and to defeat both amendments and not have us come back here for the 3rd year to vote against organized crime and to let's close the door and give law enforcement the opportunities that they need to prosecute these people and run these roaches out of the state of Georgia. Mr. Chairman,
You
Mr.
have a
President.
question if you...
Yes.
Chair recognizes Senator from the 6th for a question.
Does the senator yield?
Yes.
Isn't it true that the bill in its current form forces all pain management clinics from here forward to be owned entirely by physicians?
Yes, it does.
Isn't it true that this amendment, amendment number 2, just suggests that the clinics be owned by 51% or more?
51% or more.
51% or more physician-owned.
Yes.
My question is what about this amendment seeks to kill the bill?
Yes, it does. And he knows it. And he did not present this amendment to me beforehand, unlike, is customary in here, and I don't know why he did. I understand he's standing up for the physicians in his district. But, if you want to come back, like I said, the 3rd year, come on back. We'll fight over it again. If you want to leave that door open in Macon, Georgia, leave that door open. His practice is grandfathered in. He has no reason to complain about this.
No further questions, Senator.
Thank you.
Chair, that's all. You're going to withdraw your amendment? Chair recognizes the senator from the second.
Mr. President, I withdraw amendment number 1.
Without objection, amendment number 1 has been withdrawn. Question now is on amendment number 2. All of those in favor, rise, stand, and be counted if you're in favor of amendment number 2, authored by the senator from the 18th. Shall senators move the yeas and nays? Shall the yeas and nays be sustained? Shall the yeas and nays be sustained? 5. All those in favor of amendment number 2, authored by the senator from the 18th, will vote aye. Those opposed, no. Secretary will unlock the machine. Chair recognizes Senator from the 45th.
Mr. President, is it not true that if you are voting with the children of Georgia that you will vote a red light on this amendment?
Senator has been very clear on her position. On the amendment, the yeas are 18 and the nays are 29, and the amendment has failed. Question now is, does any other senator wish to speak for or against the bill? Is there objection agreed on the Port Committee which fail to pass the bill? Chairs none. Port Committee is agreed to. Shall the main question be now put? Are there any objections? The chairs none and the main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All of those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 45 and the nays are 44 and the nays are 5. And this bill, AMC Rex constitutional majority, is therefore adopted. The Secretary will read House Bill 235.
House Bill 235 by Representative Earhart of the 36th and others. A bill to be entitled an act to amend Chapter 30 of Title 43 of the OCGA relating to optometrists so as to revise the definition of optometry and for other purposes. The Committee of the Senate on Health and Human Services recommends that this bill do pass by substitute. The Senate Health and Human Services Committee offers the following substitute to House Bill 235. A bill to be entitled an act to amend Chapter 30 of Title 43 of the OCGA relating to optometrists so as to revise the definition of optometry and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 49th to present the bill.
Thank you, Mr. President. I rise to bring before you House Bill 235. House Bill 235 revises the applications of pharmaceuticals used in the optometry practice. It provides for continued use of hydrocodone and no more than 48 hours with an immediate follow-up by a medical practitioner. It provides continued prescriptions of corticosteroids, but for no more than 14 days. Georgia law currently exempts continuing ed requirements for optometrists over the age of 65 years old. This removes that exemption. Currently, there are 32 states that have similar legislation. It was voted out of committee 8-0 unanimously. And I would yield for questions, Mr. President. I'll yield the well if there are no questions.
No questions, Senator.
Thank you, Mr. President.
Question on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is there objection? Agreeing to report of committee which fail pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? The chair is none and the main question is ordered. Shall this bill now pass? Question on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary, unlock the machine. On the pass of the bill, the yeas are 47 and the nays are 1. And this bill, having C-Rex constitutional majority, is therefore adopted. Secretary will read House Bill 242.
House Bill 242 by Representative Willard of the 51st and others. A bill to be entitled an act to amend Title 15 of the OCGA relating to court so as to substantially revise, supersede, and modernize provisions relating to juvenile proceedings and enact comprehensive juvenile justice reforms recommended by the Governor's Special Counsel and for other purposes. The Committee of the Senate on Judiciary recommends that this bill do pass by substitute. The Judiciary Committee offers the following substitute to House Bill 242, a bill to be entitled an act to amend Title 15 of the OCGA relating to courts so as to substantially revise, supersede, and modernize provisions relating to juvenile proceedings and for other purposes. Through with the order, Mr. President.
Chair recognizes the senator from the 54th to present the bill.
Thank you, Mr. President. Members of the Senate, it is my privilege to present to you House Bill 242, which is brought to you by the administration and the Special Counsel on Criminal Justice Reform that the governor convened years ago. It is apparently sponsored by the Georgia pulp and paper industry. As you will notice, this is a voluminous bill you have in front of you. And I'm going to try and hit the highlights. This is a bill that's been debated much in this building and across the state, and I don't want to belabor too many points, but I do think it is worth pointing out that you are doing something today that's worthy of our purpose in coming to this building. We are going to take steps that is going to make Georgia a better state to live in and going to make the lives of Georgia better through the juvenile justice reform that you signed today. We will be dividing designated felony between Class A and Class B to allow us to better target those severe or dangerous crimes committed by our younger citizens, and then also better allocate our resources within our YDC system. It costs the state of Georgia the upside of $91,000 annually to incarcerate a child or detain a child in a YDC. Worse than that is that of the children we send, over 60% are reoffending within 3 years of going out. We can and should do better. Senators, there are a lot of reasons to vote for House Bill 242. There are financial reasons. There are reasons in terms of the burden on our court. There are reasons in terms of the economy of practice in juvenile court. We're going to bring a lot of the provisions into the one code section, one title, so that practitioners will have all the law in their hands. But the best reason are the young men and the young women that are walking up and down the aisles today as your pages, because this leaves them a better state than we have today. I'd ask for your favorable consideration. If there are questions, Mr. President, I'll try to address them. Otherwise, I'll yield the will.
No questions.
Thank you, Mr. President.
Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? Is the objection agreed and report of committee which fail pass the bill? Chair hears none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? The chair hears none. Main question is ordered. Shall this bill now pass? Question is on the passage of the bill. All of those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. Chair recognizes Senator from 49th.
Isn't it true, Mr. President, this also is a vote for the children and the young people of Georgia? And we have the distinguished Commissioner of the Department of Juvenile Justice in the gallery, Mr. Avery Niles.
Very good. Thank you very much. Good to see Avery up there. On the passage of the bill, the yeas are 47 and the nays are 0. And this bill, having received requisite constitutional majority, is therefore adopted. Secretary will read House Bill 268.
House Bill 268 by Representative Hardin of the 148th and others. A bill to be entitled an act to amend Article 1 of Chapter 9 of Title 2 of the OCGA relating to dealers in agricultural products generally so as to remove cotton and eggs from the definition of agricultural products and for other purposes. The Committee of the Senate on Agriculture and Consumer Affairs recommends that this bill do pass by substitute. The Senate Agriculture and Consumer Affairs Committee offers the following substitute to House Bill 268. A bill to be entitled an act to amend Article 1 of Chapter 9 of Title 2 of the OCGA relating to dealers in agricultural products generally so as to remove eggs from the definition of agricultural products and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 11th present the bill.
Thank you, Mr. President. I rise today to ask for your support of this bill, House Bill 268. This bill was worked on during the summer by my predecessor, the distinguished senator from the 11th District, and along with the chairman of the House Ag Committee. This bill changes the bonding requirements for dealers that are purchasing commodity products in our state. The prices of those commodities has increased dramatically over the last few years, and the bonding requirements need to be raised in order to protect our farmers. If there are no questions, I yield the well, Mr. President.
Chair recognizes Senator from 22nd for a question. No question from the senator from 22nd. You can yield the well, Senator.
I yield the well.
Questions. Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? All those in favor of the bill vote aye. Those opposed, no. Secretary, unlock the machine. On the pass of the bill, the yeas are 46 and the nays are 3, and this bill, having received requisite constitutional majority, is therefore passed. Secretary will read House Bill 287.
House Bill 287 by Representative Hatchett of the 150th and others. A bill to be entitled an act to reassign the Division of Archives and History of the Office of the Secretary of State and transfer governance thereof to the Board of Regents of the University System of Georgia and for other purposes. The Committee of the Senate on Higher Education recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes Senator from the 17th. Present the bill.
Mr. President, members of the Senate, House Bill 287 simply takes the Division of Archives and transfers it from the Secretary of State to the University System of Georgia, and the archives are located next to Clayton State University, and everybody's in agreement with it, Secretary of State's office, the Governor's office, and the University of Georgia. I ask for your favorable consideration, and if nobody has any questions, Mr. President, I'll yield the way.
Senator from the 38th is recognized for a question.
Will the senator yield?
Yes.
Once we transfer this from the Secretary of State's office and move it to Regents, presently there's a provision in there that says that the general public should be able to visit the archives on every Saturday between 9:30 and 3:30, except for legal holidays. Is that provision provided for in this new bill?
The hours will stay the same, and with the help of students at Clayton State, they think they're going to be able to open another day or two a week.
Thank you,
That's the goal.
Senator.
No questions, Senator. Does any other senator wish to speak for or against the bill? Is the objection agreed and report of committee which fail pass the bill? Chair is none. Report of committee is agreed to. All those in favor vote aye. Those opposed, no. Secretary unlock machine. On the pass of the bill, the yeas are 46 and the nays are 0, and this bill, having received constitutional majority, is therefore passed. Secretary will read House Bill 345.
House Bill 345 by Representative Benton of the 31st. A bill to be entitled an act to amend Chapter 3 of Title 47 of the OCGA relating to the Teachers Retirement System of Georgia so as to clarify and consolidate the definitions of the term teacher and for other purposes. The Committee of the Senate on Retirement recommends that this bill do pass by substitute. The Senate Committee on Retirement offers the following substitute to House Bill 345, a bill to be entitled an act to amend Chapter 3 of Title 47 of the OCGA relating to Teachers Retirement System of Georgia so as to clarify and consolidate the definition of the term teacher and for other purposes. This is to certify that the substitute bill is a non-fiscal retirement bill as defined in the Public Retirement System Standards Law. Through with the order, Mr. President.
Chair recognizes the senator from the 12th. Present the bill.
Thank you, Mr. President. Today I rise to ask for your support of House Bill 345. This bill clarifies and consolidates the definition of the term teacher as it relates to the teacher's retirement system. The definition of teacher should simply state that all personnel employed in a permanent status position not less than half-time by a TR employer or TRS members. The current definition has at times been confusing to TRS reporting employers, resulting in personnel being enrolled in incorrect retirement plans. HB 345 does not affect or change the eligibility requirements for TRS membership. Mr. President, if there are no questions, I yield the well.
No questions, Senator.
Thank you.
Questions on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Does any other senator wish to speak for or against the bill? All those in favor of the bill vote aye. Those opposed, no. Secretary, unlock the machine. On the passage of the bill, the yeas are 45, the nays are 0. This bill having zero constitutional majority is therefore adopted. Secretary will read House Bill 349. Senator from the 54th will stand by.
House Bill 349 by Representative Golick of the 40th and others. A bill to be entitled an act to amend Chapter 7 of Title 5 of the OCGA relating to appeal or certiorari by the state in criminal cases so as to provide the state with more direct appeal rights and for other purposes. The Committee of the Senate on Judiciary and Non-Civil recommends that this bill do pass by substitute. The Senate Judiciary and Non-Civil Committee offers the following substitute to House Bill 349. A bill to be entitled an act to amend Chapter 7 of Title 5 of the OCGA relating to appeal or certiorari by the state in criminal cases so as to provide the state with more direct appeal rights and for other purposes. Amendment 1, Senator Bethel of the 54th and others offer the following amendment. Amend the substitute to House Bill 349 by replacing is clearly outweighed by with clearly outweighs on line 637. Amendment 2, Senator Bethel of the 54th and others offer the following amendment. Amend the Senate Judiciary and Non-Civil Committee substitute to House Bill 349 by inserting after the semicolon on line 20 the following: to revise eligibility for a HOPE grant at a technical college or university institution and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 54th. Present the bill.
Thank you, Mr. President. Members of the Senate, I am back to talk about justice in Georgia. House Bill 349 is, for the most part, the cleanup from last year's adult criminal justice reform bill. Again, the work of the special counsel. A lot of hard work done. The former judiciary chair, the current judiciary chair, judiciary non-civil chair, a lot of hours have gone into this work. A couple of items that are not sort of what we would call cleanup, that are unique to the cleanup. In Section 1, there are some elements relating to appeal, clarifying opportunities for the state to appeal on evidentiary matters. You'll see the amendments before you. I'd ask your favorable consideration. The first addresses basically I won't say typographical error, it was a language error that sort of followed this all the way through to be clarified. And the second item addresses one of the governor's agenda packages that relates to the HOPE grant and eligibility, and we're adding it to the section in this bill that deals with the ability to get a GED through HOPE grant dollars while incarcerated. I'd ask for your favorable consideration, Mr. President. I would yield for questions. If there are none, I would yield the well.
Chair recognizes Senator from the 42nd for a question.
Will Senator yield?
I yield.
I have a question about Amendment 1.
Yes, sir.
As I read that, it does have the same words, but it dramatically changes the meaning of the sentence. Isn't that right?
That's right. That's why I say I don't think it was a typographical error. I think it was literally a writing error that sort of went through all of the various eyes that saw it until Chairman Jay Neal captured it even this week.
And we yield for a follow-up question.
I yield.
What this section of the bill does is it says that if you have a felony charge dismissed or null prost, or you get found not guilty, the question then is, can that record of your arrest be restricted? And what the bill, as it reads now, without the amendment, it says that essentially it'll be restricted unless the public interest clearly outweighs the harm to the individual.
That's correct.
And you want to change it to the individual has to show some harm before it'll be removed. Is that right?
That you are reading it exactly correctly, and that is, I believe, the way the bill was intended to be drafted, and the opposite language was put in.
Okay, thank you.
Thank you.
Chair recognizes Senator from 39th for a question.
Will Senator yield?
I yield.
I have a question regarding Amendment number 2 that we're just getting on our desk even as we speak. I recognize the language because it's very similar to the language on a bill that I co-authored with the senator from the 42nd.
It is.
Earlier this session. And I'm just, first question, if the senator will yield, is I know there's a bill, I think there's at least one, if not two bills with this language at one stage or the other, either in the House or the Senate. Why are we doing it in this bill here and now?
Legislative economy, Senator. I mean, you are correct. That was an initiative. My good friend from the 42nd, my friend Stacey Evans from the House, and the governor has adopted that as a part of his legislative package. And we're opening, to talk about Hope grants. And here's an opportunity to get that initiative through and to his desk.
Will the senator further yield?
I yield.
And because I'm supportive of the general thrust of what you're trying to do, I'm just, and I'm not going to ask, I don't think I'm going to ask for a germaneness ruling because, I'm supportive of this. But are you concerned at all that the multiple subject matters or germaneness might be at risk here?
Senator, I am not. Each senator is entitled to their own opinion. The bill itself deals specifically with Hope Grant expenditures as it relates to the pursuance of GED. This is Hope Grant dollars. We're not opening up the whole Hope title. We're not opening up all those other provisions. This deals exclusively with Hope Grant, and so it's an opportunity to reach that population.
Chair recognizes Senator from the 49th. Excuse me, the 40th.
Senator Yield?
I yield.
I'd like to go back to Amendment 1. If someone is found not guilty, what this amendment does is put the burden of proof on them now to have their name expunged from this thing. And why would we do that? If the person's found not guilty, I don't understand why the burden of proof should be on the individual versus the public interest. I mean, we're completely flip-flopping this with this language as outlined by the senator from 42. And why would we do that? If someone's found innocent, they shouldn't have this continue as a record part of their name. I mean, what's the rationale for this, I guess? How does this clearly affect the public interest to the detriment of the particular individual who's been found innocent?
Senator, it's a valid question. It's an issue that is, I think, open for dispute as to what interest the state, meaning the people of the state, have in knowing arrest history. Many would argue, and it may not be acceptable, it may not be the view that you adopt, but many would argue that it is relevant for law enforcement to know of previous arrests if they're going to show evidence of previous transactions that may not have resulted in a conviction, but may have been a course of conduct or a pattern of activity. That's the traditional reason for law enforcement being aware of previous arrests and prosecutions, even when they're not fruitful. And I think what the language is looking for is a way to address those situations where the harm of that information outweighs the public interest in knowing.
Further, you one more?
I yield.
Am I wrong that, look, if someone's found innocent, we're going to have this follow them the rest of their life because they were arrested, even though they've been accused, but they were found innocent, and yet this is going to track with them, is what you're saying. That just doesn't quite seem right in our country that we live in. That versus how that benefits the public interest because someone was arrested for something and found innocent. I just don't understand. I'm sorry, but I'd have to disagree with your amendment. I apologize, but I'm sorry.
I respect the senator's opinion.
Chair recognizes Senator from 38 for a question.
Will the senator yield?
I yield.
I am noticing throughout this bill that the word knowingly, line 109, 110, 123, 124, 130, 131, 132, yes, etc., has been deleted. And in reading this, I understand what it's saying. Any person who knowingly sells, delivers, or brings, okay? I'm okay with any person who sells and delivers, but I'm not quite okay with any person leaving the knowingly out with bring. With bringing, only because I know sometimes people could put something into someone's luggage or whatever, and so you don't knowingly know you were bringing something. Yeah. And I know you all have debated this, I'm sure, in judiciary, but could you give me why you went on and included that part into that?
Yes, I can, Senator, and thank you. And it's here, and I skipped right over it in my notes, and I apologize for that. The elimination of that language is a specific response to a Supreme Court ruling, Wilson versus the state, that held that in drug cases, because of the way the statute reads now, when we delineate based on weight, grams, ounces, those sorts of things, that the way it reads now with knowingly being attached to the requirement, that we have to then prove, again, beyond a reasonable doubt in the criminal context, that the defendant actually definitively knew the weight involved, and that's why it's been attached to knowingly. And so it's a specific response to that line, that case, and that line of reasoning. You still have to have both what they call the actus reus and the mens rea in a criminal context. It just means you have to have done something, and you have to have had the appropriate mental state to do it. But you don't have to have known that it was over an ounce. You don't have to have known that it was over a kilogram or whatever the standard is when we break it out for purposes of the level of the offense. And so we're saying that's not something that a defendant, we don't have to prove that they knew that it was over a certain amount.
Thank you, Senator.
Thank you.
Chair recognizes Senator 23rd for a question.
Thank you, Mr. President. Will the senator yield?
I yield.
Going back to your amendment, number one, if the bill were not amended, isn't it true that it would have an absurd reading? That is, in order to prove your burden to restrict the record, you'd have to show that the public's interest outweigh the individual's interest.
That's correct. The person seeking expungement would have to then go and prove the opposite of what they want to prove.
Right. This just is a common sense reading with the amendment.
I agree with the chair.
Thank you.
No further questions, Senator.
Thank you, Mr. President. I yield the will. I ask for your favorable consideration.
Chair recognizes Senator from the 42nd.
Thank you, Mr. President, and thank you to the senator from the 54th for bringing this bill and to the work of the Criminal Justice Reform Commission who came up with it. I would wanted to speak essentially to the two amendments. The First Amendment, I believe, undermines the bill, and I think it undermines the ability of our criminal justice system to acquit somebody. And the question is, if you get acquitted, should you have that wiped off your record by showing that you don't have to show that it's going to be harmed, that you're going to be harmed at all? And the bill changes flips the statute and the burden of proof, and I do not support, and I would urge people to vote against Amendment 1. On Amendment 2, however, I think it's incredibly important. The senator from the 54th mentioned, and the senator from the 39th mentioned, that we have been working on this particular policy change for quite some time. There is a crisis in our technical college system. The number of people going to technical colleges dropped so dramatically last year as a result of the HOPE reforms that we passed, or that y'all passed, over the course of the last few years, that we have to make some change. And I think that this is a step in the right direction. Keep in mind that this only applies in technical schools. And in technical schools, you have a different type of academic environment. You have a fast track to jobs, and it is the type of place where we want to maximize the number of students who are being able to go and graduate and move on to jobs. This is a great way to do it. It is an example of good ideas rising to the top, regardless of where they come from. Representative Evans has already been mentioned, and she and her staff spent a lot of time on this particular policy research. This has appeared, as Senator from the 39th mentioned, in several other pieces of legislation. It is a good policy option for our state. It is important for our technical schools. It's important for our economy. It's important for the students out, and many of whom are later in their careers. It's just good policy. It's good to see bipartisan support for it, and I'd urge your favorable consideration of Amendment 2. Thank you. If there's any questions, I'd be happy to yield, Mr. President.
No questions, Senator. Thank you for your passion on this, and you'll have an opportunity to vote on that tomorrow. Is there objection to Amendment number 1? Without objection, Amendment number 1 is adopted. Amendment 1? Is there objection on Amendment 1? There is objection on Amendment number 1. All of those in favor of Amendment number 1, rise, stand, and be counted. If you are in favor of Amendment number 1, rise, stand, and be counted. Reverse. On Amendment number 1, the yeas are 22 and the nays are 15, and Amendment number 1 is adopted. Now, on Amendment number 2, Chair recognizes Senator from the 18th.
Mr. President, parliamentary inquiry.
State your inquiry.
Although I'm very sympathetic with what I see in Amendment number 2, I'm compelled to ask the chair for a ruling on germaneness.
It's not germane. You'll have an opportunity to vote on that tomorrow on the floor. State your inquiry.
3-519.6, how is a change to 519.5 non-germane?
You wish to appeal the ruling of the chair?
Just parliamentary inquiry.
You'll have that vote tomorrow. The question is on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Without objection. Does any other senator wish to speak for or against the bill? Is there objection granted to the Report of Committee which fail to pass the bill? Chairs none. Report of Committee is agreed to. Shall the main question be now put? Are there any objections? Chairs none. Main question is ordered. Shall this bill now pass? Questions on the pass of the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 46, the nays are 1. This bill, having records constitutional majority, is therefore passed. Secretary will read House Bill 473.
House Bill 473 by Representative Welch of the 110th and others. A bill to be entitled an act to amend Chapter 60 of Title 36 of the OCGA relating to provisions applicable to counties and municipal corporations so as to add the option of fiscal year contracts and for other purposes. The Committee of the Senate on State and Local Governmental Operations recommends that this bill do pass. Through with the order, Mr. President.
Chair recognizes the senator from the 52nd to present the bill.
Thank you, Mr. President. This bill relates to our counties and our municipalities. Some of them operate on fiscal years, and they have multi-year leases and purchases. And in the past, they've only been able to do this on a calendar year basis. This will let them do it on a fiscal year if they're on that basis. It's just a cleaning up bill that will help them with their annual budgeting. If there's no questions, I'll yield the well.
No questions, Senator.
Thank you.
Does any other senator wish to speak for or against the bill? Is there objection? Agree in the report of committee which fail pass the bill. Chairs none. Report of committee is agreed to. Shall the main question be now put? Are there any objections? The chairs none. The main question is ordered. Shall this bill now pass? Questions on the pass the bill. All those in favor of the bill will vote aye. Those opposed, no. Secretary will unlock the machine. On the passage of the bill, the yeas are 48 and the nays are 0, and this bill, having records constitutional majority, is therefore adopted. We're done with the calendar, so yeah.
Bill 171, House Bill 347, and House Bill 443 be removed from the table.
We got to read each one of them. Is there objection to removing them from the table? There is objection. Be voting on them one at a time, removing them from the table. The first one is House Bill 171. All those in favor of removing it from the table will vote aye. Those opposed, no. Secretary, unlock the machine. Removing it from the table. On the motion to remove the bill from the table, the yeas are 37, the nays are 13, and the bill has been removed from the table. HB 171. The next bill. You want to debate the bill? All right, give me the numbers. Now the question is on the removing from the table HB 347. Is there objection? All those in favor will vote aye. Those opposed, no. Secretary will unlock the machine. On the motion, the yeas are 34 and the nays are 13, and the motion to remove the bill from the table has been sustained. Now the question is on House Bill 443, removing it from the table. Is there objection? All those in favor vote aye. Those opposed, no. Secretary, unlock the machine. Chair recognizes Senator from the 42nd. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
What are the rules with respect to having copies of these bills?
10 minutes per side.
No, copies of the bills, copies of the physical bills.
I can't hear them. Oh, the copies of the bills are being distributed now.
Thank you, Mr. President.
Yeah. I would like to have the Senate's attention for just a moment. We still have two wonderful pages that are with us that have worked all day. We are grateful for their wonderful participation today. Natalie O'Connor and Mary Emily Landers that is here. So thank you very, very much. On the motion, the yeas are 35. The nays are 13, and the amendment, or excuse me, the motion has passed. All right, Chair, Secretary will read House Bill 171.
House Bill 171 by Representative Riley of the 50th and others. A bill to be entitled an act to amend an act creating the Board Commissioners of Fulton County, approved December 3rd, 1880, as amended particularly by an act approved April 12, 1982, and for other purposes. The Committee of the Senate on State and Local Governmental Operations recommends that this bill do pass. Through with the order, Ms.
Chair recognizes the Senator from the 32nd to present the bill. Remember, we will be on a clock on this issue. Senator, suspend for just a second out of the well. Senator from the 19th, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, I know that it's possible that somebody other than the author of the bill present the bill, but isn't it customary that the author of the bill present the bill?
I'm sorry, I'm confused at this point. These are House bills. Who's carrying the bill? What did I? I'm sorry. Who was supposed to be carrying the bill? Who's? Well,
Mr. President, I understand it's a House bill. Who did the House member recommend to carry the bills?
I have no idea. I mean, I'll be very candid with you. I don't know. It's between these two. If the senator from the 56th, are you wanting to present the bill? You're recognized to present the bill. Time has been. Okay, all right. Hold. Everybody just hold on for a second, okay? Senator from the 39th, what purpose do you rise? State your inquiry.
Would the President be so kind as to explain to the body the rules of debate on this bill?
The rules of debate. The rules of debate is 10 minutes each side. Am I right, Mr. Secretary? Excuse me? Correct. Subject to the chair shortening that. Senator from the 36th, what purpose you rise?
Mr. President, could you clarify if the rule about a bill laying on the desk it applies in this situation? These bills have just been apparently they're being distributed. I'm not sure if they're.
No, I think a bill that has been laid on the table, okay, can come off the table at any time, and there's no time limit by which it has to rest on the desk before it can be debated or taken up. It's immediately before you because it has gone through the process.
Thank you for that clarification.
All right. I have a lot of lights on right now. Is someone wishing to be recognized at this point? All right. Senator from the 56th is recognized to present the bill.
Thank you, Mr. President. Ladies and gentlemen, House Bill 171 is redistricting for the commission seats for Fulton County. As you're aware, when we came into session in the summer of 2011 for the purposes of redistricting and reapportionment, we have to redraw the maps every 10 years based on the change of the census. And it is now time to do the same for Fulton County. There are municipal elections that will be coming up this November. And during that November, we will be doing that in newly drawn seats. There are currently 7 members of the Fulton County Commission. There will continue to be 7 members of the Fulton County Commission. In the current map, there are 5 commissioners that are elected at large, by districts, and 2 at large. We'll be changing that to 6 commissioners elected by district and 1 at large, which is consistent with the Voting Rights Act, which is to assure that we have voting and people who are elected that are closest to the people in which they represent. These maps were studied and they were prepared to assure we met all of the necessary provisions for the Georgia Constitution and for the Voting Rights Act, so we can get these cleared through the Justice Administration and be prepared for elections. I would like to commend the folks in the redistricting office and all of those in the House and the Senate who worked together to provide a map that is consistent with the same maps we did in 2011, which in the first time in history were passed through the Justice Administration and met all the criteria necessary to be improved. It was a bright spot in Georgia's history after so many before, which were dark spots. With that, Mr. President, I will yield the will.
Yielding for any questions? Okay, yields the will. Senator yields the will. Chair recognizes Senator from the 32nd.
I want to thank the senator from the 56th first for his work here on this, as well as the senator from the 28th, the senator from the 21st, the senator from the 48th, and without naming everybody, the entire Fulton County delegation, Democrats and Republicans alike. Just in follow-up, not to add on what the senator from the 56th stated, essentially these redistricting maps comply fully with requirements in federal law, and they're fair and they're balanced, and the maps moving forward would be fully reflective of the population changes over the last, from 2000 to 2010. And with that, I will yield the well. Thank you very much. We commend this to you, and we hope to have your support of this as we move forward, fully representing the interests of Fulton County. Thank you.
Senator's not going to yield for questions. Not yielding for question. Time is still on the clock for those wishing to speak for the bill. Is there anyone? We have a floor substitute. Secretary will read.
Senator Tate of the 38th and others offer the following substitute to House Bill 171, a bill to be entitled an act to amend an act creating the Board of Commissioners of Fulton County approved December 3rd, 1880, as amended, particularly by an act approved April 9th, 1993, so as to change the description of the commissioner districts and for other purposes. Through with the order, Mr. President.
Chair recognizes Senator from the 38th to present her substitute and speak in opposition to the bill.
Mr. President, colleagues, 2 weeks ago in the House chamber, Georgians witnessed one of the most extreme examples of placing politics over people, a process that we have seen under this gold dome in many years. After hours of debate on local legislation impacting Fulton County, a small but vocal group of elected officials lacked an initial 2/3 majority to pass their bill. Not satisfied with our legislative process, these House members made the decision to disregard the will of the body and staged a large hostage situation by tabling all other local Democratic legislation until their desired outcome was achieved. That outcome meant that local Fulton County legislation was rammed through the House, and now we have a number of bills that will essentially rob Fulton County of its finances, its elections process, and the ability of its citizens to build multiracial coalitions and elect representatives of their choice. House Bill 171 is emblematic of the top-down legislation seen in these recent antics played out in the House with little regard or respect for all of the citizens of Fulton County. It is an attempt to tell the majority-minority county of Fulton that the citizens' rights to elect candidates of their choice will not be protected or defended. Opposition to gerrymandered redistricting maps created in House Bill 171 is not about elected officials nor about politics. Opposition to House Bill 171 is about speaking up for the voters' abilities to be heard and represented. Fulton County is a majority-minority county, 45.3% black, 7.9% Hispanic, which means the Fulton County population is near 60% minority. It is essential for candidates to build multiracial coalitions in order to be successful countywide. House Bill 171 would render this nearly impossible because the proposed maps would destroy a multiracial at-large district and place it, let me say that again, a multiracial at-large district, and place a predominantly white North Fulton district in its stead. This legislation is not about voters, and it has no ground other than to further partisan domination, as both black and white candidates have recently won elections in Fulton. Senators, House Bill 171 has not been subjected to the rigors of ordinary legislation that we see each day in this chamber. A few partisans redrew the map in 2011 and used those new district lines to seize control of the Fulton County delegation. That delegation has members that do not live in Fulton County. They have constructed this new county commission map with no concern for the fact that the maps do not accurately represent the electorate of our county. More than 1/3 of the members of the Fulton County delegation live outside of Fulton County. Not only did the Atlanta Journal-Constitution recently report that the senator from the 28th must drive at least 20 miles from Newton before he even touches the edge of Fulton County, but previous elections results show that only 1.4% of the votes cast for that senator came from Fulton County. A handful of states, Georgia among them, with legacies of poll taxes and literacy tests, require that redistricting maps be approved by the Justice Department. Through the lens of the Voting Rights Act, the Justice Department ensures that all voices are heard, and that is not the case with these maps. It is anticipated that a number of citizens' rights organizations will file lawsuits because these maps do not fairly represent Fulton County voters. In 2013, which this proposed Fulton County map, we see race being used as an attempt to ignore existing and emerging population trends and to destroy the ability of the people to build multiracial coalitions within their communities. This is not only morally wrong, this is unlawful. Redistricting is fundamentally about the voters, and in Fulton County, minority voters comprise nearly 60% of the population. More importantly, these populations have aligned themselves with majority white constituents to demonstrate the political power that they desire. Under this map, partisans are realigning districts to eliminate multiracial coalition voting across Fulton County. When the dust settles between these pairings and the creation of the GOP forced districts, partisans intend to knock off county commissioners that were duly elected by the voters. It is the nature of the majority to scrabble for its due, and it is the nature of the majority to maximize its power. And while this dynamic exists in a political arena, it is at its very core our public servants whose role is to serve the people. All of the people. This means that those who call themselves Republicans and those who call themselves Democrats are responsible first and foremost to the voters without regard to politics. These highly partisan maps are nothing more than a greedy political grab to control the Fulton County Commission. The losers will not be the elected officials. The losers will be the voters of Fulton County. I urge you, fellow senators, not to succumb to the extreme partisan politics and the gamesmanship that played out in the House chamber. I urge you instead to take the high moral road and remember that our constituents, our voters, are at the core of this debate. Very quickly, let me kind of tell you about these maps. 248, which is a substitute, which was introduced this year. It was also introduced last year as Senate Bill 359, which was, of course, in 2012. After the Congressional, Senate, and House redistricting occurred in 2011, the Fulton County Commission got together to begin the Fulton County redistricting process. They were instructed to follow the process that was followed by the state. The commission held public hearings in the fall before they began the process of redrawing the district so that the citizens of Fulton County could give testimony and be included in the process. After the maps were drawn by the commission, they then had public hearings to have further input from the public before they passed the map. They brought the commission-approved map to the Fulton County Senate delegation, presented the map, explained the process, and the map was advertised and dropped, creating Senate Bill 359 last year. The legislation was sent to reapportionment and the redistricting committee. The reapportionment and redistricting committee had a hearing on the bill and allowed public input, but did not act on the legislation. This bill 171, as previously stated, did not follow this process. Please, I ask you not to vote for House Bill 171. Thank you.
Chair recognizes the senator from the 39th. Time is a little over 3 minutes remaining. 3 minutes.
Mr. President, members of the Senate, in this abbreviated discussion, I do want to make reference to the senator, the majority leader, who came to this well and talked about honor this morning. And he was very serious, and I agree with him that this body, the upper chamber, is a different place than the other chamber. And that's why I'm real concerned. We were told yesterday that this bill was going to lay over until Monday. And then we found out that the football had moved. And now we're here today, and I feel a little bit ambushed. No, not a little bit ambushed. I feel greatly ambushed, but it speaks to the process. It speaks to how this process has changed. And we need to keep that in mind because it's relevant legally and morally. The fact of the matter is we have not had any public hearings except one abbreviated public hearing over on the House side on this bill. And we were told even then, we had the public come, we were told we legislators would be able to ask questions in that joint public hearing, and guess what? That was not true. We could not ask the people who came before us. Any questions? I have handed out this material which quotes the House President Pro Tem, and this gives us a good idea of what this is all about. The House President Pro Tem is quoted as saying, "We can cut Fulton County down to size until we get Milton County. My goal is that we reduce the thumbprint of Fulton County on your lives and your pocketbooks such that in a few years, Atlanta and South Fulton County will not fight us on recreating Milton County because Milton County will be insignificant. We will begin the process next year. My goal is not to recreate Milton County. My goal is to end Fulton County and bring government closer to the people." But even then, we have to ask ourselves, why this attitude? It's been reported to me, and the House President Pro Tem can deny it or she cannot deny it. We have been reported that there's been reference that the intent is to make white Democrats in Fulton County an extinct group of folk. And that probably gives us a window to what's going on here. Fulton County is, as has been said by the senator from 38, 60% non-white. And if you look at a citywide district, a countywide district, 60% non-white, the countywide seat that is being replaced in the plan that we are looking at is about 80% white and about 20% non-white. It seems to me that if the Voting Rights Act means anything, it means that you cannot dilute the right of African Americans to elect a candidate of their choice. If that's what this means, if the Voting Rights Act means that, then going from a district which is in effect 59% non-white to 20% non-white seems to me to strike at the core of the Voting Rights Act. And that's why I believe that the Voting Rights Act is violated by House Bill 171. Second point, and this is not about incumbents, this is not about politicians, but when you put two African American incumbents in the same district, we have to ask the question.
Time's expired.
Mr. President, I appreciate this opportunity. I ask my colleagues to vote against this bill. We will have opportunities to talk to these issues in the near future on a continual basis between now and the end of the session. I yield well.
Question is on the floor amendment authored by the senator from the 38. Is there objection? There is objection. All those in favor of the floor amendment will rise, stand, and be counted. If you're in favor of the floor amendment. Nays and nays, shall the yeas and nays? All those in favor will vote aye. Those opposed, no. Secretary, unlock the machine. You are voting on the floor substitute authored by the senator from the 38th. Chair recognizes senator from the 56th. What purpose you rise? State your inquiry.
Isn't it true that the members of the Fulton County delegation would oppose this amendment and ask our fellow senators to vote red, no?
I think the senator has great passion and expressed that view. Chair recognizes senator from the 38th.
Inquiry.
State your inquiry.
Is it not true that the floor sub is the map that is fair to Fulton County and was approved by the Fulton County Commission as a whole, approved and sent over here for us to work with?
The senator has great passion for which she speaks as well. On the floor substitute, the yeas are 12, the nays are 29, and the substitute has failed. Question now is on I got some lights on here. Okay. Question now, does any other senator wish to speak for or against the bill? Is the objection agreed and report of committee which failed pass the bill All those in favor of this local bill will vote aye. Those opposed, no. Stick to unlock the machine. Chair recognizes Senator from the 56th.
Parliamentary inquiry.
State your inquiry.
Isn't it true that members of the Fulton County delegation would ask all of our colleagues to vote green because it would be a good thing for Fulton County and the entire state of Georgia?
I think the Senator speaks with great passion. Chair recognizes Senator from 38th.
Parliamentary inquiry.
State your inquiry.
Is it not true that the citizens of Fulton County would really prefer us having a map that is fair, and this is not the map that they chose?
Senator has great passion. Senator from the 35th, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that this bill would pit 2 African American incumbents together and 2 other African American at-large members, and it's
Senator has great passion. The yeas are 31, the nays are 11. And HB 171. Why is that light coming on? Close out the Senator from 13's light, please. All right, now the Secretary will read House Bill 347.
House Bill 347 by Representative Riley of the 50th and others. A bill to be entitled an act to amend an act to create a Board of Elections and Registration for Fulton County, Georgia, approved March 30th, 1989, so as to revise the manner of appointment of the members of the board and for other purposes. The Committee of the Senate on State and Local Governmental Operations recommends that this bill do pass. Through with the order, Mr. President.
Senator from 39, what you have you're going to speak. Okay. Who's presenting the bill? You? Senator from 32nd is presenting the bill. Recognized to do so.
Senators, House Bill 347 is related to regards the Fulton County Board of Elections, and it simply provides that there will be several appointments to the Board of Elections, 2 coming from the Democratic Party, 2 coming from the Republican Party, and then 1 appointment to the Board of Elections will be a member from the Fulton County House and Senate delegations, and that individual will be the chairman of the delegation. This makes sense. This measure makes sense for a number of reasons. There's been issues that have been related to the Fulton Board of Elections for quite a while. If I said education, I meant elections a few minutes ago. And I commend to you House Bill 347. I urge you to vote green to make some changes to the Board of Elections for Fulton County. That'll yield the well, Mr. President.
You wish to take any questions? I'll take one. He will take a question.
Take a question.
Chair recognizes Senator from 39th.
Bill.
I do, Senator. Trying to find my bill.
Is it not true that any issues that you referenced regarding the Fulton County Board of Elections will not be solved by this partisan solution? Because in fact, the gerrymandering of Fulton County Senate districts, creating a majority Republican delegation, would in effect ensure that a Republican is appointed by the Fulton County delegation. Is that not true?
That is not true. And the reason for these changes is because of the past issues related. And if we always do what we've always done, we'll always get what we've always gotten. And with that, I will yield the well. And if you'd like to present your case before the Senate, I look forward to hearing that. Thank you.
I'm going to be glad to.
Any senator else wishing to speak for the bill? Chair recognizes Senator from the 39th and 36th to speak. 36th. Recognized to speak in opposition. Time has begun.
Thank you, Mr. President. Colleagues, I rise in opposition to House Bill 347. And I think this has been said a few times in the past, but I don't think it can be, repeated too often, and that what we're witnessing is an effort to make a unilateral usurping of local control under the guise of a local delegation making these decisions and bringing these bills, including House Bill 347, to you as local legislation. There's a long and ugly, stained trail that leads us today to these debates, and that is the map drawing that was done last year and why it was done that way. This legislation today, that's before you right now, will put us in a posture where Fulton County, a majority-minority county, is dictated to by a virtually all-white party. What this bill would do would have a gerrymandered Fulton delegation pick the chair, the permanent chair of the Fulton Elections Board. There is no other county in this state that has an election board member chosen by the state county delegation. None. In all of Georgia's counties, not one. So here we come with this bill that came as a result of gerrymandering. Do you know that those of us who represent Fulton County in the main have 175,000 inhabitants in our districts, and they're all Fulton County citizens, as opposed to people who are drawn in and may have 800 people or 10,000 people that actually live in this county. So you've got a gerrymandered situation, which currently 13 Republicans have been drawn into Fulton with a majority of their districts falling outside of county lines. But they're mandating taking away representation from Fulton voters. The county commission has had the authority to appoint a member to this elections board from time immemorial. This would strip that power from the county commission, a county commission lawfully elected by the citizens of Fulton County. And this is such a slap in the face to the citizens of Fulton, to the county, one of the largest counties in our state, and a county that's an economic driver for the state's economy. And I will say to you, and you have on your desk if you care to look at it, this quotes a person who is a signer. This quotes a signer of the bill, the gentlelady from the 47th House District. She's quoted speaking to people in North Fulton in the neighborhood newspaper. She says, "We can cut Fulton County down to size until we get Milton County." Because she says there'll be a North Fulton majority in the House delegation and the Senate delegation as a result of the maps that were drawn. She says, quote, "My goal is that we reduce the thumbprint of Fulton County on your lives and your pocketbooks such that in a very few years Atlanta and South Fulton will not fight us on recreating Milton County because Fulton County will be insignificant. We will begin that process with the next legislative session." And she said this before the session. She said, "My goal is not to recreate Milton County. My goal is to end Fulton County and bring government closer to the people, but it'll take some convincing." Yes, it did. It took a lot of convincing in the House. It took a lot of convincing. It took highway robbery. It took it took hijacking people's local legislation and holding it over their heads as a threat until 119 votes could be garnered up over there, and then the Speaker had to cast the 120th vote in order to, I guess you all followed the news and knew that, in order to pass the homestead exemption, that outlandish piece of legislation. So we have seen the whole legislature held up, tied up. Here we are late in the afternoon on these bills that have been tabled, brought off the table. More of them are coming on Monday, by the way. And all of this pursuing a narrow agenda to take a majority-minority county and strip power from the voters of that county who had chosen their county commission, who have followed the laws, who have governed responsibly those people that they've chosen. And this and the whole package of bills. You know, there have been 32 bills filed. There have been 32 bills filed in pursuit of breaking the back of Fulton County. Frankly, I think it would be very easy for many of you, principled people in this chamber, to just say, you know, enough already. We all pursue agendas, but to yank the entire General Assembly, to yank the entire General Assembly around the way this is happening, it's unconscionable. And it's illegal because it's busting up the ability of minority voters in Fulton County to choose to have the candidates of their choice serve in office. I will yield for questions.
Do you want to yield for questions, or you want Chair recognize Senator from the 35th?
Will the senator yield?
I yield.
Isn't it true that Fulton County has not raised its millage rate since '91, and that's one of the few counties in this whole state of Georgia that has not raised it, and in fact has one of the lowest millage rates already, and they actually lowered it on a few times since '91.
Thank you for that question, Senator. That's the case that 1991 was the high water mark for the millage rate for our county, and the millage rate has declined since then, and we have the highest homestead exemption in the entire state of all the counties. I asked a fellow over in the House when they were asked to vote on this homestead over there, and I said, now he's a smart fellow, got plenty of sense, and a good friend of mine, known him a long time. And I said, you going to vote for that? Well, I heard y'all spending too much money. I said, you know what? We've lowered the millage rate consistently since 1991. That's 22 years ago. I'm going to yield the rest of my time to others who wish to speak. Thank you.
Chair recognizes Senator from 38 for a question.
Yes, I'll yield.
Well, the senator yield. Thank you. Is it not true that this violates the one person, one vote election law for the citizens of Fulton County?
To the lady from Fulton, you are absolutely right. It does do that.
Is it not also true that this will violate the Voting Rights Act of 1964, Section 2, by creating voter dilation?
Yes, this dilutes the vote. It doesn't. The reapportion map dilutes the vote. This particular bill thwarts the will of the citizenry in that it takes away from the duly elected county commission the ability to make this appointment.
And my last question, Senator, was: is it not true that this removes, as you said, the map will remove preferred candidates of minority voters, as it is a majority minority in Fulton County, and change it to a majority county?
That's right. The lady from Fulton is absolutely correct. This would seize the governance of the county out of the hands of a majority minority county, and have a minority within that county of folks that are not minority making the decisions for the county. And I do believe it's a violation of the Voting Rights Act, and it is an attempt to dilute the will of the majority minority county. It's quite blatant, actually, and people that learn about it are slack-jawed when they look at that map and see that people have been drawn in from as far away as 20 miles. Slack-jawed, that's exactly right. To the jaws on the ground when they hear, we have for 50 years or more been a delegation from Fulton of 4 Democrats and 3 Republicans. But with the stroke of a pen, we became a delegation. We rose from 7 to 11, and we drew in people from, I believe, 6 or 7 counties all around who are now voting and trying to take into their hands all the governance questions that we work with here in our county. And I say to you, and many of you have said to me in private, if this attempt was made on your county, you would be outraged. You would not relent. You would not cease until you had defeated these efforts. So those among you who believe in true local control, who believe in upholding the Voting Rights Act, and who oppose this kind of gerrymandered approach, or simply oppose the fact that the entire legislative process is getting hijacked by the North Fulton architects of this legislation, of these 32 bills. And it's right here, you know, I read it to you, but it's right here in black and white on paper about what this is all about. It's not any mystery. It's not any mystery. It's not about good government. I think it's about white government. You know, let's put the African American and other minority populations in Fulton County that comprise far more than half of the county's residents. Let's hold them in abeyance, and we're going to make the decisions, not them. That's what it is, pure and simple. I will yield the well if there are no further questions. Urge you to vote no on this piece of legislation, House Bill 347. Thank you.
Time has expired. Does any other senator wish to speak for or against the bill? All those in favor, vote aye. Opposed, no. Secretary will unlock the machine. Chair recognizes Senator from 56th.
President, isn't it true that the Fulton County Elections Board is under investigation by multiple agencies for its inadequacies and issues with voters, and a vote yes right now will be a first step into correcting that issue?
Sure, the senator has great passion. Chair recognizes Senator from 39th.
Parliamentary inquiry. Isn't it true that this bill is a violation of home rule in its most brazen fashion, and that it takes away from the county of Fulton the responsibility to appoint commissions and boards and authorities? Is that not true, Mr. President?
Senator has great passion, I am aware. On the passage of the bill, the yeas are 31, the nays are 13, and this bill is passed. Secretary will read House Bill 443, last bill for the day.
House Bill 443 by Representative Willard of the 51st and others. A bill to be entitled an act to amend an act providing for the appointment of magistrates in Fulton County, approved March 18, 1983, as amended so as to provide that the successor to the Chief Magistrate Judge of the Magistrate Court of Fulton County currently serving shall be appointed by the Governor, and for other purposes. The Committee of the Senate on State and Local Governmental Operations recommends this bill do pass. Amendment 1, Senator Fort of the 39th and others offer the following amendment. Amend House Bill 443 by replacing lines 3 and 4 with the following. The Chief Magistrate Judge of the Magistrate Court of Fulton County currently serving, by deleting and until a successor has been duly appointed on line 18, and by replacing lines 20 and 21 with the following. Be elected at the nonpartisan general election held immediately preceding. Through with the order, Mr. President.
Chair recognizes Senator from the 56th to present the bill.
Thank you, Mr. President. I know the hour grows late today, so I will be brief. House Bill 443 is making changes to the Magistrate Court of Fulton County. It's important to note, for those that are not familiar with our legal system, the Magistrate Court is the lowest level court system, and it needs to be organized to minimize the complexities and redundancies we have within the court structures and its personnel. Fulton County is the only county, one out of 159 counties, where the Magistrate Court is operated and administered under the state court, and the Chief Magistrate is appointed by the state court judges. That is one out of 159. The Chief Magistrate will be a nonpartisan elected position, and it will be appointed full-time by magistrates, including judicial officers, and should be approved by the majority of the Superior County State Court judges, and should work under the direction of the Chief Magistrate. The Chief Magistrate will typically assign cases, set court sessions, appoints other magistrates with the consent of other Superior Court judges, and sets the policy for the Magistrate Court. And with that, Mr. President, I'll yield the well.
Chair recognizes on the 35th. Senator from the 35th.
Thank you, Mr. President. I rise in opposition to House Bill 443. 443 is nothing more than a naked power grab. The administration is trying to take power from the voters, and supporters of this bill are enabling him. Currently, the Fulton County Chief Magistrate is elected by Fulton County judges who are elected by Fulton County. And this makes sense. Fulton County judges know the day-to-day issues facing judges in Fulton County. They are in the position to evaluate who has the skill set to be an effective magistrate and who is uniquely qualified to work in of the busiest court systems in our state. And the rights of voters are protected because the judges are held accountable through elections. It does not make sense for supporters of this bill to remove the expertise of the judiciary and have voters directly elect a magistrate, but that is not the major problem with this bill. The real problem is that the governor gets to slip a handpicked person into the position with absolutely no oversight. And his appointee will get to serve for 4 years before the voters of Fulton County even have a chance to be heard. Then this hand-picked appointee will get to run as the incumbent with all the advantages of incumbency. And unlike any other elected official, including everyone in this chamber, this hand-picked appointee will be gifted that advantage without even having to earn it by winning an open election or winning as a challenger. There's never been any problems with the magistrate system in Georgia, so what are we trying to fix? Nothing. We're just trying to appease a mean person with mean-spirited legislation. You may be asking yourselves why this legislation is worded this way, and the answer is clear. It gives the governor more power. And I'm sure he already has someone in mind to whom to give this position to. I am proposing an amendment to this bill to remove this absurd loophole and power grab. The amendment that's going to be introduced by the senator from the 39th would simply begin electing the judge as soon as the current judge's term expires without allowing the governor to give incumbency to a hand-picked appointee. I ask you to vote no on this and yes on the amendment, and refuse to allow this absurd power grab. Mr. President, I yield the well for the amendment.
Senator has yielded the well. Who wishes to be? Senator from the 39th can also speak to his amendment, and we'll have time yielded.
I used to watch late night TV a lot, and my favorite character on late night TV was Karnak, the Magnificent. And I've got an envelope here with the name of the person who will be appointed the Chief Magistrate of Fulton County. I'm not going to divulge my powers right now, but I'm going to deliver this to the Secretary of the Senate so he can seal it. And what did Karnak do? Seal it in a hermetically sealed mayonnaise jar. And if I'm wrong, so be it. But I don't think I'm wrong. We know this is about partisan politics. The person who's going to be appointed the chief magistrate judge already been selected. This is naked political partisan power grab at its worst. Come on, let's be real. You know, stop dumping on Fulton County, will you? because the person's been selected, they want to give them the power of incumbency. Y'all ought not to be on the other side of the aisle. Y'all ought not to be proud of this. Particularly, this is a governor who has at the very least, a weak history of appointing judges in Fulton County. If I'm wrong, you can correct me. But all those judges that this governor has appointed in Fulton County have been white men. They've been white males. And I bet you, I hope I'm proven wrong. I hope somebody finds out, Senator Ford, you were wrong-headed, and I'll come down here to this well and I'll admit it. But that's the reality. And that's why I have this amendment to offer to you, asking you to vote for an amendment which would take away the governor's authority to appoint the chief magistrate, let him run, whoever it is, white, black, male, female, Democrat, Republican, it would be a nonpartisan race, but have them run without the power of incumbency. Let's play fair. This is, at long last, as the saying goes, have you no shame. I would ask you to vote for my amendment and prove me wrong. Let the person who wants to be the chief magistrate in Fulton County, let him run for office just like you and I did. Nobody selected you. Senator from the 21st, you ran hard and you won. And you're here now, representing your folk. You didn't need anybody to appoint you. Run, get vetted by the people. Don't get vetted by a politician. Get vetted by the people. Mr. President, I'll yield the well unless there are questions.
Is time expired? No? Are you yielding?
I'll take questions if there are any.
Chair recognizes Senator from the 42nd. Are you wishing to speak? Senator, will you yield your time to the Senator from the 42nd? He will yield his time. What? No.
Thank you, Mr. President. I rise today because I feel like I have to repeat a speech I gave the last time we went through redistricting on the floor of this body. There is a limit to how far you can go in undermining people's abilities to elect the candidate of their choice. The federal law protects those rights. And the bottom line is, when you take a county commission and you undermine people's abilities to make multiracial coalitions, and instead you want 3 districts that are white and 3 districts that are black, that's not looking forward, it's looking backwards. And it's looking, and the next thing you do is you pack a Fulton delegation with people from outside of Fulton County who are dominated by districts that are gerrymandered in the first place to be majority white or majority black, one or the other, and you've got only black districts and only white districts. That's looking backwards. And then you give power to that gerrymandered delegation over the Elections Commission. At some point, someone's going to say it's gone too far. And then we're going to have another bill tomorrow and another bill the next day. And we're doing this at the point, essentially, of dramatic threats. And one of the things the Justice Department's going to look at is, did we follow the normal legislative procedure? And all of us saw what the House did yesterday, and it's anything but normal. You had people all over this state saying, have the Republicans in Atlanta gone crazy? And I don't know the answer. And the big question on this bill is, again, we don't trust the people in this county to vote right. Well, we're not allowed to make that decision. And the bottom line is, this is a bridge too far. I do not believe that these laws as a package will survive scrutiny. They certainly don't survive the scrutiny that they deserve in here. They don't survive the scrutiny they would get from a normal legislative process. That's why it's been abused. That's why it's been turned upside down. That's why I'm going to vote against it. I hope you will too. Thank you, Mr. President. I'll yield.
Questions on the adoption of the floor amendment. Is there objection? Is there objection to a floor amendment? There is objection to the floor amendment. All those in favor of the floor amendment will vote aye. Those opposed, no. Secretary, unlock the machine. You are voting on the floor amendment that is authored by the senator from the 39th and others. Chair recognizes Senator from 56. What purpose you rise?
Thank you, Mr. President. Parliamentary inquiry.
State your inquiry.
Thank you, Mr. President. Isn't it true that Fulton County delegation would ask all our fellow senators to vote no, red, and then vote for the underlying bill afterwards? We ask them to vote no.
Chair recognizes Senator from 39th.
Query, Mr. President.
State your inquiry.
Isn't it true that this amendment would give back to the people, the voters of Fulton County, the right and the ability to vote for their own elected officials?
Chair recognizes Senator from 35th. What purpose you rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that one person cannot decide for the whole Fulton delegation, and all the Fulton delegation members who actually live in Fulton County or who represent the majority are against this?
Senator has great passion. On the floor amendment, the yeas are 11, the nays are 30, and the amendment has failed. Question now, does any other senator wish to speak for or against the bill? Is the objection granted? Report of committee which failed pass the bill. Chairs none. Report of committee is agreed to. All those in favor vote aye. Those opposed no. Secretary unlock the machine. Chair recognizes Senator from 56.
Thank you, Mr. President. Parliamentary inquiry.
State your inquiry.
Isn't it true that this is final passage and we'd ask that you vote yes on this bill to help out Fulton County?
Senator has expressed his view. Chair recognizes Senator from 38th.
Parliamentary inquiry.
State your inquiry.
Isn't that true that this legislation subjects Fulton County to state rule instead of local rule and usurps the local control, and Fulton County delegation would ask you to vote against this piece of legislation?
Chair, Senator's got great passion on this issue. On the pass of the bill, the yeas are 29, the nays are 12, and this bill, having received requisite constitutional majority, is therefore passed. Chair recognizes Senator from 39th. What purpose you rise?
I rise to make a motion to reconsider the vote on the last bill.
There is objection. You are serving notice on it. That'll be that vote will happen first thing tomorrow morning. Senator from the 32nd, what purpose you rise?
Parliamentary inquiry.
State your inquiry.
Since the senator from the whatever number was not the does not have the authority to make the motion for reconsideration, he's not the sponsor of the bill. Not on the prevailing side.
Yeah.
He was not on the prevailing side. Is that correct?
Senator, I'm not quite sure where that. I mean, any senator has a right for reconsideration. It's treated as a general bill.
May I approach?
Huh?
May I approach?
Sure, yeah. The senator has served notice on reconsideration. That will happen tomorrow. Chair recognizes the senator from the 49th.
Mr. President, I move that the Senate insist on its position on substitute House Bill 487.
Is there objection? Or I'm sorry, read the caption, read the caption.
House Bill 487 by Representative Ramsey of the 72nd and others. A bill to be entitled an act to amend Chapter 12 of Title 16 of the OCGA relating to offenses against public health and morals so as to correct a cross-reference and for other purposes. Through with the order, Mr. President.
Is there objection? Without objection, the Senate has insisted on our position. Chair recognizes the senator from the 18th. The distinguished majority whip.
Thank you, Mr. President. I move the Senate stand adjourned until 10 a.m. tomorrow morning.
10 a.m. tomorrow morning. Read the announcements.
Rules will meet upon adjournment in 450 cap. Natural Resources and the Environment is moved to 9 a.m. tomorrow morning in 450 cap. Special Judiciary is moved to 9 a.m. tomorrow morning in 125 cap. Finance, Education and Youth will be at 5 p.m. in 450 cap. Finance will be at 5:30 p.m. in 450 cap. Sorry, Education and Youth is in 307 CLOB. This is almost impossible to read. It's in 450 cap. You want to clarify? For clarification, Education and Youth is meeting at 5 p.m. in 307 CLOB. Finance will meet at 5:30 in 450 cap.
I've got to change these. I've got to go back.
All those in favor of adjournment will say aye. All those opposed, no. The ayes clearly have it. We stand adjourned.